Hello, my name is Sue Miller, and together with Ed Davis, I head up the Finance Litigation Group at Stevenson Harwood. Welcome to the second in our Autumn 2015 series of 4 short webcasts. In today's webcast, Alan Ward, an associate in our Regulatory Litigation Group, will be reviewing the key recent developments in the new accountability regime for individuals in banking, the Senior Managers and Certification regime.
In less than 6 months' time, the Senior Managers and Certification regime will begin to take effect, marking the coming to fruition of perhaps the most significant regulatory reform since the financial crisis. When the FCA and PRA first consulted on the new accountability regime in July 2014, it was proposed that only so-called relevant firms, UK banks, building societies, credit unions and PRA-designated investment firms would be covered. However, following the publication of a series of further consultations and guidance papers over the past 12 months, it has become clear that the regime will apply more widely. This short webinar will review some of the most notable developments amongst the body of guidance that has emerged from the PRA and FCA in the past year, including the Senior Managers regime and the controversial presumption of responsibility, the scope of the certification regime, including proposed extension to traders, the position of UK branches of foreign banks and overseas staff, and the conduct rules and revisions to regulatory reporting requirements. Beginning with the Senior Managers regime, in February, the FCA and PRA published a joint consultation paper revising the approach to non-executive directors, or NEDs. This revised approach follows widespread concern across the financial services industry that the application of heightened regulation would reduce the efficacy of NEDs, compromise independence, and deter highly qualified individuals from taking on non-executive roles with banks. In the February paper, the regulators propose that NEDs with specific responsibilities, such as chairman and chairs of the Risk, Audit and Remuneration Committees, will be covered by the SMR and will require regulatory pre-approval and fall subject to heightened regulation. However, the paper also confirms that the FCA Non-Executive Director SMF 15 function will be removed from the SMR. Consequently, standard NEDs will not be covered by the SMR or fall within the certification regime. In the February consultation paper, the PRA also provided guidance on the application of perhaps the most controversial aspect of the new regime, the presumption of responsibility, and also the reasonable steps defence. The PRA set out indicative, non-exhaustive examples of 1. The circumstances which may inform the PRA's consideration of whether an individual took reasonable steps, such as whether any delegation was appropriately arranged, managed and monitored. 2. What steps may be relevant to this determination, including seeking and obtaining appropriate expert advice or assurance, whether internal or external. And 3. What evidence the PRA may rely on, such as board minutes and, unsurprisingly, statements of responsibility and responsibilities maps. An FCA consultation on the presumption of responsibility was published in March, proposing similar rules and guidance to that published by the PRA in February. Final rules and handbook text on the presumption of responsibility are expected this autumn. In March this year, the Treasury announced that the new accountability regime would be extended to UK branches of foreign banks. In August, the FCA published near-final rules on how the new regime would apply to foreign banks in practice. Specifically, the new regime will apply to incoming branches of non-UK firms that have permission to accept deposits or deal in investments as principal in the UK. The Treasury estimates that 174 branches will be affected in total. A distinction is established in the FCA's proposed rules between EEA and non-EEA incoming branches. This reflects the split of home and host state supervisory responsibilities under the relevant single market directives. For non-EEA branches, the FCA will require the branch to nominate and seek approval for 2 specific senior management functions. The first is the Executive Director function, SMF3. This will operate in a similar way to the existing director-controlled function, CF1, for non-EEA branches. The second relevant senior management function will be called the Other Local Responsibility function, SMF22. This is a new function which will operate in a broadly similar way to the Other Overall Responsibility function, SMF18, for UK relevant firms. With respect to the compliance function, where branches already have an individual approved under the current CF10, that individual will be able to grandfather across to SMF16 without needing to be reapproved. If a non-EEA branch is not currently required to have an individual approved to CF10, this will not change under the SMR. However, where a non-EEA branch is not required to have an individual approved to SMF16, they must still ensure that the prescribed responsibility on compliance is allocated to an appropriate senior manager within the branch. The certification regime will apply to staff at non-EEA branches that are either based in the UK or dealing with clients in the UK. With regard to senior managers, the conduct rules apply to senior managers without territorial limitation. EEA branches will be required to have an individual approved to the EEA Branch Senior Manager function. This function, SMF21, will apply to individuals responsible for a significant business unit, for example, accepting deposits. Importantly, EEA branches do not need to put forward their head of compliance or chief compliance officer for approval to the compliance oversight function, SMF16, as this is a matter reserved to the home state. For EEA branches, the certification regime will only apply to individuals based in the UK, and individuals in EEA branches will be subject to the conduct rules, but only in relation to matters that are within the scope of the UK's responsibility as host state regulator. Many responses to the FCA's original consultation on the new accountability regime noted the anomaly that many banking employees currently approved as Control Function 30 or CF30 will not be subject to certification. Taking on board these responses, the FCA launched a consultation in July this year on extending the certification regime to staff undertaking wholesale market activities. The FCA proposes to add two new significant harm functions to the certification regime. The first will broadly reflect the current CF30, albeit with the definition of clients expanded, to include not only retail clients, but professional clients and eligible counterparties. This will mean that a large part of a bank's trading population will now be caught within the certification regime. The second new significant harm function will specifically address algorithmic trading. This function will bring those with a responsibility for the deployment of trading algorithms within the compass of the certification regime. It is important to recall that the certification regime is limited by statute to regulated activities. Both the new functions will apply to UK relevant firms and incoming EEA and non-EEA branches of relevant overseas firms. The regulators have confirmed that individuals subject to either the SMR or the certification regime will be subject to the conduct rules from commencement on the 7th of March 2016. Firms will have a year after this, until the 7th of March 2017, to prepare for the wider application of the conduct rules to other staff. Following consultation, reporting of actual or suspected breaches of the conduct rules by senior managers under the SMR will still have to be submitted to the FCA by a firm within 7 business days of the firm becoming aware of the actual or suspected breach. However, the FCA has confirmed that reporting of suspected breaches and actual breaches of the conduct rules by any other staff subject to the rules will now only be required annually, as opposed to quarterly. The reduction in the frequency of reporting will go some way to reducing the compliance burden on relevant firms. Specifically, where an investigation is ongoing, a firm will now have a longer period to assess whether an alleged or suspected breach is founded or not. The FCA has stated in the July paper that it would not expect firms to report suspicions that have already been investigated and proven not to be founded. Only suspicions that are either proven or that remain open at the time of reporting will need to be included. Crucially, the existing regulatory obligations on all regulated firms to notify the regulators of matters of which it would reasonably expect notice, and specifically to report a significant breach of a rule immediately on becoming aware of it, remain. Developments over the past 12 months have had the effect of widening the scope of the new accountability regime. However, even following numerous additional consultations and guidance papers that have emerged since July 2014, much remains unclear about how the regulators expect some key aspects of the new regime to apply in practice. Final rules and guidance on the presumption of responsibility, due in the autumn, will be particularly eagerly awaited by compliance and legal professionals, and not least of all, by the population of senior managers that will be affected. Looking beyond March 2016, it seems clear that politicians and regulators will ultimately seek to apply the new accountability regime even more widely. Both the Parliamentary Commission on Banking Standards and, more recently, the authors of the Fair and Effective Markets Review gave every indication that in the long term, the new regime will come to replace APA completely and apply right across financial services.